Yes.
From supplementary list, item number 1.
This is a matter which came up yesterday.
My lord, we have filed a stay application, my lord, that is registered as Miss Case 14, my lord.
Where is the prayer, entry prayer?
In the Miss application, my lord, at page 9, my lord.
Yes.
Miss Case number 14.
Next file. Next file.
Page 9.
Admit notice. Interim order permitting the appellant to retain the gold bangle seized till further orders of this court.
My deeply.
Item number 2.
This is
6.
You need not say the appellant is absent. You need not say heard or is reserved. Yes. 1 to 4, 1 to 5, 6. Yes. I think the service is not complete.
It's complete, my lord.
Complete.
Complete.
Who is appearing?
Long time back. I'm appearing for the appellants, my lord.
Who is appearing with the other respondents?
I'm appearing for the
For all.
state respondents, no, except for the
The
private
private
respondents.
respondents,
Who is appearing the private respondent?
no one, my lord. The service was complete since a long time back, my lord.
So, where is the proof?
My lord, we have filed the affidavit of service, my lord.
Annexure 2. This is with regard to respondent,
Respondent 5, your lordship.
respondent 5. This is with respondent 5 is Srimati
Delby Rindatyam.
The respondent has filed, the appellant has filed a proof of service with regard to service of notice on the private respondent. From annexure 2 to the service of notice, affidavit of service dated 22nd March 2024, it's clear that the postal authorities have given remarks that the article has been delivered on 17/2/2014. There's no representation for the private respondent. Since the service is complete on all the respondent, come in order to give one more opportunity to the private respondent to make the submissions. Matter is urgent to so and so. We make it very clear that in case of no representation by the private respondent in the next date of hearing, orders will be passed based on the records available before this court. What is the issue?
My lord, the issue here is, my lord, the appellants herein, my lord, they were, in the year 2013, my lord, they were appointed, my lord, temporarily in the fourth grade post, my lord. They continued for some years, my lord. And suddenly in the month of year 2015, my lord, till 2015, till 2018, my lord, for this period, suddenly their salaries were stopped, my lord. Stopped for indefinite time, and they had been.
But you have been working,
my lord, and they had been running from pillar to post all the time. No explanations were forthcoming, my lord. Eventually, being aggrieved, my lord, there were 32 numbers of similarly situated fourth grade post, my lord. So 9 of them approached the honorable court, my lord, for releasing of their salary. So, my lord, appropriate directions were given to the authority, my lord, and while complying with the order, my lord, they disbursed the salary, my lord. But, my lord, seething with anger, my lord, they came up with a, my lord, order saying that their service won't be renewed. But my case is that, out of the 32, the 9 who approached, my lord, they were singled out, my lord. They were not renewed. Rest of the, my lord, 19 are still working.
so according to the discrimination,
My lord, that apart, my lord, they gave, I was appointed in the year 2013. They gave a complete go-by to, my lord, Umadevi case, my lord. So, my lord, I should not suffer.
remember this. Last time we said,
My lord, I am relying on a lordship judgment in my lord from Madras High Court, my lord. That is with me, ma'am.
What is it, madam?
Your lordship, these were temporary appointees, your lordship, who had not come, whose initial entry was not by the regular course of recruitment, your lordship. So in the meantime, your lordship, their services were no longer extended. And this is absolutely wrong to say, Your Lordship, that seething with anger, the respondents have not renewed their tenure, Your Lordship. That is not correct, Your Lordship. This because all the illegal.
Whatever
it
be
was
the
a
reason,
general
whatever be the reason, Umadevi case is of the year 2006. Correct.
Yes, correct, Your Lordship.
You have given them appointment, ignoring Umadevi's case. You have given a go-by to Umadevi's case. Whenever it is convenient, you are saying Umadevi's case is there, they cannot be regularized. Is it a sanction post in which they have been employed?
My lord. Yes, ma'am.
So, Lordship, now, Your Lordship, these appointees were made till regular appointees are made recommended by the District Selection Committee, Your Lordship. So now these posts have already been filled up by the regular appointees who have come through the regular selection procedure, Your Lordship.
So there are no vacancies.
There are no vacancies. These have already been filled up, Your Lordship.
That is absolutely incorrect, my lord. I'll satisfy your lordship.
But are there vacancies?
My lord. That apart, my
There are
lord.
no vacancies.
Why the 9 have been singled out who approached the honorable court? Rest are still serving, my lord.
They are serving.
My lord.
Your Lordship, may kindly hear us, Your Lordship. And in the meantime, this item number 1 is also.
Where is the order of the learned single judge?
This is at page 70, Your Lordship.
Page 70.
Page
70, my lord.
17.
My lord.
Not 17,
70.
Your Lordship. An extra 8.
Oh, yes.
That apart, my lord, some of the appellants here are under compassionate appointment, my lord. Compassionate appointment, my lord.
How many are?
2 of them, my lord.
They are all temporary appointees, Your Lordship.
Can it be temporary, my lord, compassionate appointment?
We asked, say, how can there be a compassionate appointment on temporary grounds?
Your Lordship, it was not given, they were not given any regular appointments on compassionate ground, Your Lordship. And because the compassionate scheme, appointment on compassionate scheme had been abolished way back in 2010, Your Lordship. These people were just appointed to meet the exigencies of the situation at the relevant time, Your Lordship.
So there is no compassionate appointment scheme at all here.
No, Your Lordship. Since 2010, it has been abolished.
My lord, my
Sir, we'll come to you. We'll come to you. Where is the proof that it has been abolished?
I concede, my lord. 2010, my lord, in the
has been
month of November, my lord,
There is a
11,
notification to that effect, Your
Yes.
Lordship.
it was abolished, my lord.
Yes. But even assuming that the temporary appointees, when other persons are continuing, giving a go-by, depriving these 9 persons, amounts to discrimination.
Your Lordship, I do not know how my friend says that the other persons are still continuing, Your Lordship, because there is nothing to show in the record that the other people, out of the 31, 9 were given, not extended, their service was not extended, and the rest were still continuing. There is nothing to show on record except for a statement made by them, Your Lordship. That they are continuing is not there on record, Your Lordship.
My lord,
When the next vacancy arises, we'll take it that there are no vacancies. When the next vacancy arises?
That I have to seek instructions, Your Lordship. I am not aware as to.
my lord, in the first round of litigation, my lord, I had made a specific averment to the fact that only the 9 had been singled out, rest are, my lord, still in service. That was never replied to, my lord.
That is right. Now, 9 persons are already in employment, barring you.
My lord,
In your place, somebody has appointed, correct?
my lord, ad hoc has been replaced by ad hoc, my lord. That is not the law, my lord. That is against the constitution.
Those persons are also.
Your Lordship, they are regular appointees, they are recommended by the district selection. As of now, Your Lordship, they are regular appointees and no ad hoc appointees were made in their place, Your Lordship.
So at present, there are no,
Please respond.
at present, there are no ad hoc appointments.
No, Your Lordship, in these posts, Your Lordship.
these posts.
Yes, there are no ad hoc appointments. This is my instruction, Your Lordship.
My lord, they are
They have been recommended
Ad
by,
hoc position, persons are replaced by ad hoc position, that is wrong. There is judgment of Supreme Court is also there. One.
Which is why, my lord, I have erred
No, no,
private
1 minute.
respondents, my lord.
Now that they have filled up the post, it may be wrong. You are going, by appointing these 9%, some 9% are going to be displaced. They must be heard.
My lord, that is why I have erred them as respondent number 5, my lord.
We are not the parties in this case, Your Lordship, because these people,
It means only 1%.
My lord, yes. One person, there are six, my lord, writ appeals, my lord. 3 is not
six
before,
writ appeals.
my lord.
6 writ appeals.
3 has not approached this honorable court, my lord. 6 out of the 9. Out of the 9, 6 has approached this honorable court, my lord. That is my case, my lord. At the time of hearing, my lord,
All the 6 respondents are private respondents.
my lord.
Different private respondents or same respondent?
No, different respondents, my lord.
Six
My lord.
different private
My
respondents.
lord. And the other point is that, my lord, as my friend said, my lord, as he stated that it was abolished, the scheme was abolished in the year 2010, November 11th, my lord. My application for compulsion and appointment was pending since the year 2000, my lord, 8 and 9, my lord. Prior to the even, my lord, this
Prior
scheme
to
was,
you?
prior to the abolition of the scheme, my lord.
Your application was there.
My lord, yes. That was considered subsequently.
Subsequently, they have not been.
My lord, yes. I'll
Nothing on
satisfy your
record to show, Your Lordship, nothing on record to show that they had applied for compassionate appointment prior to 2010. Nothing on record to show that, Your Lordship.
We'll come
These
to that
people were
hearing, my lord.
appointed temporarily in the year 2013 and afterwards, Your Lordship.
Last year, judgment of Justice Kaul is there,
Yes, ma'am.
2023.
My lord.
If the scheme is there and subsequently abolished, you have to take into account whether they have applied on the date of the scheme.
My lord.
As in the date prior.
That is my case, ma'am. I'll satisfy your lordship.
But anyway, you may get relief only for 2%. What about other 6 or 7% or 4%?
My lord, I'm relying on your lordship's judgments, my lord.
That is the judgment.
I'm covered by those two.
That is the judgment.
My lord, it's here. ma'am. I've compiled it, my lord.
You can't say my judgment is there, my judgment is there.
Maybe also
As
have
long
a-
as long as I write the judgment, I'll remember everything. Once they deliver judgment, I'll forget.
My lord.
a copy may also be furnished to us, Your Lordship.
Yes. Which page, sir?
My lord, page starts, my lord, should be 7, my lord, but it's not paginated. Page 1, my lord. No. Page 7, my lord. After my bullet points, my lord.
Page 1. Page 1?
After my bullet points, my lord. There is a case of, my lord, State of Tamil Nadu versus S. Thiagarajan, my lord.
Okay.
It is judgment order dated 3/3/2021,
1 minute.
2021, my lord.
Right, take out this. Fifth March. This is 5th March. This one's 5th March. It's not here. Thinking that I have it like
My lord,
computer memory.
I'll supply another copy,
In this, my brother is having a copy.
my lord.
In the types
Sir, we have not received a copy, Your Lordship. If they would
not
kindly
ready to-
do.
Anyway, we'll hear it in the, next week we'll hear it. Not a problem. Anyway, go through.
He is not bound to furnish a copy.
Unless directed by the honorable court.
No. You must furnish. It's a duty of the council to serve a copy on the other side. You cannot take it, take the other side by surprise.
Relevant paragraph will be 11, my lord.
If we rely upon the judgment of Justice Satyadev,
No, my lord. Your lordship's
para
judgment
11, 8060 and LG 153.
is 3/3/2021, my lord. The first one. Relevant paragraph 11.
Yes. Relevant, Umadevi's case may
My
not
lord.
be applicable to facts and circumstances against as the person agent and petitioner here should not have been appointed in continued service.
That apart, my lord, there is another judgment of your lordship, my lord. That is your 28/6/2021, my lord. Relevant paragraph is 9.
What about para 12?
Yes, my lord, that is also applicable.
How is it applicable? It is applicable in favor of the respondent. In the case of
Nine will be
backward
applicable in my
employment
case.
to the petitioner, so as to enter in the benefit of the next line is very important. More so, the document produced with the petitioner have not been disputed. Now everything has been disputed by the other side.
The officials appointing authorities who had appointed the employees like the petitioners based on the fact that cannot be let go scot-free. So eventually, my lord, the liability comes upon the appointing authority, my lord. The employees should not suffer, my lord. Then the next paragraph, my lord, in this. If there had been any irregularity committed by the appointing authority, it is the appointing authority who should be proceeded against, my lord.
That's what, that is the judgment of Justice Satyadev.
My lord.
In Food Corporation of India. Do you have a copy of the judgment of Justice Satyadev?
My lord, I have got the bullet points here, my lord.
No, 1986 TNLJ 153, is it available?
My lord, it's.
Yes. That's all.
Lordship, we'll fix a date for hearing. Lordship.
What is that? We'll go through in past orders.
Lordship, I have still a lot of,
Huh?
I have to make some more submissions, Lordship.
What is submission? Some more submission.
No, I have not started my submission, Your Lordship.
You start.
Okay, Lordship.
You start. Your case is that they are not regular appointees.
No, they have not gone through the regular course of recruitment, Your Lordship,
Correct.
as established by the rules.
Correct.
So, and they had worked for some years, Your Lordship, that is not denied. They were given extension. Initially, it was for a period of 3 months. Then gradually, they were,
Periodical extension was
given to them.
without any break in service.
There was break in service, Your
How many
Lordship.
months?
3 days, 3 days break every
Three?
time. 3 days break with every 3 days
3 days break.
with every extension.
So
Your
it is an
Lordship.
artificial break.
That is what Your Lordship had said on the last occasion, Your Lordship. Then, Your Lordship, they have come to the court saying that their salary was not released from 2015 to 2018, Your Lordship. And the Honorable Court, Your Lordship, was pleased to direct that to consider release of their salaries, which was also done, Your Lordship. And when their salary was released, Your Lordship, there was a letter, Your Lordship, by which the Director of Health Services, the respondent number 3 here in Your Lordship, because all these appointees, these temporary appointees had been made in the district level, Your Lordship, by the district medical health officer, not by the competent authority who is the Director of Health Services. She had done it on her own level and she was giving regular extensions, Your Lordship. So the Director of Health Service, while directing release of the salary in compliance to the High Court's order, Your Lordship, also stated that henceforth no fresh appointees on temporary basis should be given, and these are illegal and irregular appointees, and that all those who have given, not only for these 9 as trying to be projected by my learned friend, but all, it was a general saying that no,
What about the other persons who have joined along with these persons?
we are not aware of their position, Your Lordship.
Not
It
very,
is only their statement, Your Lordship. It says that there were 31 appointees, out of which 9 were singled out, and they were not renewed, Your Lordship. This is the only statement they have
you
made.
are disputing it. According to you, there is no. Where is the proof that
Because the general,
31 persons have been
My lord,
appointed?
even in the earlier first round of litigation, my lord, I had made a specific averment to that effect, my lord. Time and again, my lord, the state is
There is a proof that other persons have been working along with you, other persons were working with you.
My lord, kindly come to page 53, my lord.
53. Yes.
Yes, these are the, my lord, 31 numbers of, my lord, this temporary appointees. Out of which 9 have been singled out, my lord. Now the state is, I have made a specific allegation, the state is not coming up with, my lord, any documents to that effect. My lord, they are conceded to that fact, my lord. They have not come with any documents saying that, contradicting that.
But you have not said anything about the remaining persons in the.
Nothing.
Whether they have been, see, if you are going to say that these persons have participated in the selection, got selected and appointed, and they have not done so, is a different aspect.
Yes,
You have not said anything at all.
Your Lordship, out of these 31, Your Lordship, we still don't have any information, but some of them have been given regular appointment as they were the landowners, Your Lordship, and they had donated the land to the government.
My lord, there is nothing as such on the record, my lord.
These are all subsequent developments, Your Lordship.
Nothing on record, my
One
lord.
minute, sir. Please take page number 52. In 1 or 2 cases, you have said son of the landowner, relative to the landowner. Other names have not been reflected.
So whether they have been, they are still continuing also, we are not aware of that, Your Lordship. So I may be given some time to find out if these people are still continuing. Or what is their position as of now, Your Lordship?
My lord, nothing came out in the first round of litigation
So
today.
we'll ask them to give a detail, but we'll ask them. The appellant has come forward challenging the order of the Honorable Single Judge in denying the benefit of regularization.
My lord, I was recommended for regularization also, my lord, very department.
Regularization,
That was
but
only a proposal.
instead they have been disengaged from services. According to the appellant, there were 31 persons working along with them, and as 9 persons were agitating for getting regularization, they have been singled out and the services have been divested of. For years, for the services rendered, wages have not been paid, and pursuant to the orders of the court, wages have been paid. You would further submit that all these persons concerned in this writ appeal, 6 writ appeals, have joined the services in 2013. By artificial break, the services have been discontinued for 3 days, and that they have been employed in a job of perennial nature and in a sanctioned post. The counsel appearing with the respondent, government would submit the contesting respondent, respondent 1 to 6,
1 to 4, Your Lordship.
1 to 4 would submit that in the light of the Umar Davis case reported in 2006, so on so page 1, backdoor entry is permitted, not permitted, and that the services have been disengaged. There was a selection process in which vacancies have been identified and filled up, and at present there are no vacancies. So, it is totally incorrect to submit that all the 31 mentioned in Annexure 3 less 9 or in employment, and that the respondent 1 to 4 has permitted those persons to be continued in service. Further stated that some of them have donated land which resulted in employment to those persons or the family members, and that the compassionate appointment scheme, as stated by the appellant, has already been abolished as in 2010. When they are casual or ad hoc employees and that they have no right to the post, even in a sanctioned post, unless they are selected or recruited through proper channel, proper selection process, from a question of providing them employment and regularization does not arise. In response, the counsel appealing for the appellant would submit that though the compassionate appointment scheme has been abolished as early as in 2010, some of the petitioners have applied for employment on compassionate ground before the abolition of the scheme. Out of the 9 persons who were affected, 6 are before this court, and that the persons who have been replaced have been made as private respondent who have been served. Full stop. Since the matter requires consideration, the respondent 1 to 4 is expected to give the details of the persons who have been accommodated more so from Annexure 3 on the details of the position now they are holding and whether they have been selected and appointed by due process of law.
We'll file it by way of an affidavit, Your Lordship.
Madam?
We'll file it by way of an affidavit, explanation.
The respondent 1 to 4 is expected to file,
Before the date of the hearing.
including as to the number of vacancies available in the post, which has been sought to be, which is now sought by the appellant to be engaged, sought to be sought by the appellant. And the vacancy that is going to arise in near future. Suppose a matter after 2 weeks.
3 weeks, Your Lordship.
2 weeks, madam.
3 weeks would be sufficient, Your Lordship. I can have
pending
file my
for a long
affidavit
time.
and collect all the information also from the
We'll
district.
put it in the first week of June. First week of June.
Obliged, Your Lordship.
Declare. Huh? But the private notice has not been served. Private notice is, that also we can incorporate. அதை remove பண்ணுங்க. So that you remove it. Since the private respondent in so and so has already been served and proof of service have been filed along with the postal receipt. Well, we expect the private respondent to appear. In order to give an opportunity to private respondent to make the submission on the matter on so and so date.
Declare.
Right.
Item number 7.
Yes, sir.
Yes, may I please, Lordship. Before I come to the impugn order, I beg to narrate the brief fact of the case, Your Lordship. Here the case is, this is the case of Nokma, this Akeng land. Akeng is the land of the clan members. Here in Garo Hills.
Before stating the facts, you
Lordship.
tell us what was your prayer before the learned single judge which was not granted or granted?
Here in the land, before the landed council, I was the respondent, private respondent.
What was the prayer sought for by the petitioner?
Sought by the petitioner was to set aside and quash the order passed by the CEM, whereby the CEM of GHADC, Garo Hills Autonomous Council, passed an order setting aside the order of the EM. EM is the executive member of Garo Hills Autonomous Council, setting aside, remanding the case to the EM for giving an opportunity to let the evidence, to frame the issue, and to dispose the matter in a proper way. Now, there is that order is as per the judgment, Your Lordship. There is a landmark judgment also.
That order has been set aside.
Yes, that order has been set aside by the learned single bench,
judge.
Single judge. Now, our only contention is, now here in this, my contention is not, we are not on merit, Lordship. We are only asking the procedure, because it is the clear cut, this undisputed fact that where the title suit or the Akeng land is decided, first it has to led by the evidence. Both the party has to let the evidence file. They have to file the deposition. After filing the deposition, and then there will be a framing of issues. The suggested issue will be filed. And after discussing each and every issue.
Issue framed.
Yes, issue frame. That then only the finding will come to conclusion. Then the judge will pass the necessary order.
That is the order of the learned single judge.
Yes, Lordship. That is their Lanis. That is at page 132, my lord. In my
132.
yes, it started from 132 till 139. 139.
132 to 139.
Yes. This is very quite long order. My lord, I may read it.
What is it? The issue has already been concluded. You are trying to reopen the entire issue. That is the finding of the Honorable Chief Judge.
No, Your Lordship, the earlier, Your Lordship, even the matter of the res judicata, even that framing has to be issued. They have to say whether there is any petition, whether this matter has been pursued by the other party. Even as I said earlier, Lordship, even the matter of res judicata and whether the limitation acts come into play, all this has to be discussed. Earlier, my lord, may I check you to the page number where they have framed the issues, Your Lordship, in the earlier occasion, but then that was the opposite party they have challenged. Page
You have been
88, my
litigating
lord.
for 90 years. The issue is from 1935. You must understand, already there is an order in 1935, subject to correction. Then 2000, somewhere in 1961, then 2018.
Lordship, may I take you to page 88, my lord? Page 88 of the memo of it. 88.
Yes.
Here, Lordship, earlier this litigation was there, Your Lordship, before the EM. They have framed this issue. Some issue has been framed, but there are no evidence. Now, even this, they have framed this as much as 7 issues by the EM. But the date was, it was on 10/5/2007 that this type copy was there in the page 89. And this is the, where they have framed the issues, whether there is no course of action for filing petition for appointment of Akeng Nokma by the petitioners, whether the petitioner have no local standing to file a petition, whether the Malakapara Akeng no longer existed and completely merged with Karijora Akeng, whether opposite party is in complete and unattempted position.
What happened to the issue suggested?
Yes.
What happened?
Now what happened? This issue was suggested, and the opposite party, the private respondent, petitioner of the private respondent, have filed an appeal against this one without allowing the EM to discuss the issue.
What happened?
Then that order was here. That next order. Then this order, this framing of issue, that order was set aside.
This framing issue was set aside.
Set aside because they didn't allow to follow the procedure.
What happened to that order?
That order was on the next page.
That set aside order was set aside, or
They said
it's final?
No, this is not final. They set aside. Then after the case go on.
This order was set aside.
Your Lordship.
Correct?
Yes.
That means issues cannot be framed.
Cannot be framed. That is their contention. They cannot. They don't allow the court to frame.
Correct. This cannot be framed as an order. That has become final.
This order was set aside. Since they have challenged this order, thereafter they approached to the CEM. CEM such demand back that let there be a proper discussion of the issue. That may I take you to the another the order dated page 98, my lord. The authority part of the order. This is laying order, but I will just read it. The main authority part of the order, page 98, my lord. The last para. Last para. Henceforth, I directed the EM, IC Land and Revenue to record the statement of witnesses of both the parties and giving chance to both the sides to adducing their respective witnesses and thereafter to transfer the case record along with the statement of the witnesses before the court for adjudication. The matter send the record to the EM, IC Land and Revenue for compliance. This is the order where the CEM, my lord, is sending that.
Against this order, what happened?
Against this order, private respondent have filed a writ.
Writ petition.
Yes.
Yes.
And that this order was set aside. And then the set aside. Against that order, we are coming towards.
This order, the original order which you showed at page number 88, to issue framed, wanted to be framed.
Yes,
This was interpreted by the court.
yes.
Where is the order?
That is in the next page 92, my lord.
'92.
Yes. This is the,
1 minute.
yes. They are very clearly mentioned here, Lordship.
So once this order is there, passed by the Chief Executive Member Tura on 30th October 2007,
Lordship. In the resolution allowing the appeal. Yeah, they have allowed the appeal. The CEM has allowed the appeal. Actually, my contention is this order should not have been allowed. This appeal should not have been allowed. They should have allowed to frame the issues. There should have been framing of issues. There should have been giving an opportunity to lay the evidence, filing of deposition, and
so this is the order of the Chief Executive Magistrate with
Yes.
regard to framing of issues.
yes, framing of issues. But that framing of issues, they have read appeal saying that
What happened to this order? What happened to this order of the Chief Executive Member? Does it become final or set aside?
this, Lordship, after this order, Lordship, there is another order. Maybe this matter was again remanded back to the EM. There is another order, Lordship, 13.9, page 93, Lordship. Page 93. May I read, Your Lordship? Pursue the petition of the petitioner and the written statement of the opposite party. I have also pursued the issue suggested by the parties. At the parties on the issue of law, and also pursue the relevant record of the file relating to the Kajijora Akeng maintained by the office. Pursuant to the relevant record of the Marakapara Akeng, it can seem that Marakapara Akeng was already transferred and merged with Kajijora Akeng in the year of 1935 by the order dated 31st/7/35 of the Deputy Commissioner, Mr. W. So, in political case number 12 of 19.
Sir, you cannot be agitating at all. When will you complete? When will you not agitate? If you get a favorable order, you will not agitate. Till such time you want to agitate.
That is not the
You
case.
can't do that.
That is not the case, my lord.
That's what it appears. You are ability. Sir, from 1935, 90 years, almost 89 years. That is the finality.
Here only the contention is that maybe the appellant may be incorrect. Maybe they are not this one. But the contention is that there should be a proper while disposing the case, there should be a proper adjudication of the matter. Here it is on record. It's very clear speak that there is no evidence is recorded, no statement has been taken, no framing of issues. And there is a lordship, there is a landmark judgment, your lordship, which I would like to place it here. Even my learned senior also is aware.
Sir, we'll pass orders. Post orders. 27th of this month.
Lordship.
Sorry, we are not agreeing with you. Yes. Next. For orders on 27th.
Item number 8,
Someone. This you send it.
My lord, that 302
The
matter.
matter you argued.
Yes.
I argued, my lord.
Okay, we were asking.
Yes.
We were asking about this case only, no?
Yes.
That one gentleman came from
About the addition, my lord.
Guwahati and huh?
My lord, just to recall, my lord, the fact, 29/12/2011, a person was missing, my lord. So accordingly, village and family members went for searching, didn't
So
get
let him
it.
argue, then you can reply.
Yes. No, my lord, one judgment I am relying in, my lord, wherein my lord has dealt with it, Madras High Court, my lord, wherein in paragraph 15, 17, my lord, we'll kindly see, page 50, page 14. It starts from
We
paragraph
have
17.
a judgment from the nearest court. Always you are going to Madras.
No, my lord, the thought process, my lord, it was never argued. And my lord, passing the judgment, that thought came to the mind and it's been reflected in the judgment. That's what I want to take your lordship. Paragraph, page 14, paragraph 17, my lord. In the case on hand, the trial court has held that though the eyewitness to the occurrence had turned hostile during their examination in court, their statement recorded under 164 CRPC corroborates the medical evidence. The wounds found on the dead body as revealed in the postmortem certificate and thereby found the appellant guilty. However, strangely, the trial court has ignored the fact that when the occurrence is said to have taken place 29/2010 and a postmortem certificate was issued on 21/9/2010, the statement from the witnesses has been recorded on 6/10. So they know what is the injury and everything. And as such, my lord, that has been disbelieved and acquitted, my lord. That's not only.
Yes.
Please.
I was told that when Madras High Court, a lawyer was arguing
My lord.
from that distance. The Madras High Court previously it was like a horseshoe. Lawyers would be like this.
My lord.
He was arguing and referring to Patna High Court or some other High Court
My lord.
from that place. And the judges asked him, why don't you come nearer? God came very near. Yes. Yes.
My lord. My lord, about the facts of the case, my lord has already heard from the petitioners, my lord, appellants. So, my lord, I'll straight away go to the evidence, my lord. There are, my lord, in this case, 2 eyewitnesses, my lord. There are 2 eyewitnesses, my lord. That is PW1 and
1 minute, we'll write down this. Criminal appeal. Yes,
my lord.
2 eyewitnesses.
2 eyewitnesses, my lord. PW1 and PW2, my lord. My lord, will please come to page number 3 of the paper book, my lord. That is the 161 statement of PW1.
Page number 2.
Page number 31 of the paper book. If I may read, my lord.
Yes.
On examination him, he stated that on 29/12/2011 at about 9 p.m. he was present at marketplace at Brewer, that is a PO, my lord. He had met the victim, Sri Savas Pangrup. He was beaten, assaulted, and killed. After talking with him, he went by his own way. After some time, he heard people saying that someone was being beaten by some man. He rushed to the spot and saw the victim lying unconscious on the ground. He was bleeding from his face. At that time, he saw thumb of Saipung village, that is the appellant here in Manor. He saw thumb of Saipung village, who was still hitting the half-dead man. That market at Brewer belongs to Sri Thom. He also not known his title, but only his name and village. Meaning thereby, my lord, the PW1 knew the appellant from before. The deceased and himself belongs to the same village. Therefore, on seeing what had happened to him, he left the spot and went straight to the village and informed his parents. They all went to the spot, but his dead body was taken somewhere else. We then returned to our village, Snongrim, the next day, that is 31/12/2011, while village all men went to make a search, and about 2 p.m. we found his dead body.
This is what the senior advocate argued that your statement was recorded, examined after 65 days.
My lord, I am trying to bring forward your lordship 161, 164, and his chief. So I am trying to, my lord, establish the corroboration and the, my lord, the quality of evidence, my lord. We found his body at Umthler and took him home. On 31st December 2011, FIR was lodged and the police came and conduct postmortem at his house. That's all his statement, my lord. Now, my lord, will come to page 60 of the paper book. That is the 164 statement of PW1.
Page?
Page 60, my lord. 60.
Yes.
If I may read, my lord, 60 is the type copy, my lord. On 29 December 2011, about 9 p.m., I was present at a marketplace at Brewer. I had met the victim, led Sri Chavas Prangrap, before he was beaten, assaulted, and killed. After talking with him, I went my own way. After some time, I heard people saying that someone was being beaten up by some man. I, along with Sri Kom Patwek, that is the PW2, my lord, rushed to the spot and saw the victim lying unconscious on the ground. He was bleeding from his face. At that time, I saw Sri Thom, that is the appellant here in my lord, of Saipung village, who was still hitting the half-dead man. That market of Brewer belongs to Sri Thom. I do not know his title, but only his...
Same thing is reflected.
My lord, same thing is reflected. Now, lordship, we will come to the examination of chief, my lord. Page 39, my lord.
Yes.
I have received someone to depose in this court that I could not recollect the date and time of incident. I heard people talking about assault. Incident happened in Brewer, and I myself went to the PO and saw the victim, Sri So-and-so, was bleeding and lying on the ground. There was many people surrounding the body of the deceased victim. I saw that Sri Thom was still hitting the half-dead man. I do not know the surname and resident of the person named Thom. That I and the deceased belong from the same village. After I saw the incident happen, I rushed to the village from so-and-so to inform his relatives. After I have informed the relative, I, along with them, went to the PO again. On reaching the PO, we could not see the body of the deceased victim anymore. On the next day, the whole village went to search the body and found it somewhere nearby. Brewer. Exhibit 1 is the statement, and Exhibit 1 by 1 is my signature. I can identify the accused person, Sri Thom. He is present in the dock today.
The body was hidden. 201 is there.
Why not?
201 is there.
Yes, 201 is also there.
Is also there.
Yes.
charge order to someone.
Only 302, my lord. Charge been framed under 302.
302.
302, yes.
No, they said that the body was not found, whether he has
302 by 34 is.
taken the body and hidden somewhere, whether 201 is.
Later on, it was recovered.
Yes.
Page 21 is the charge, my lord, with 2 heads, my lord.
Yes.
My lord, I have read, my lord, read out 161, 164, an examination chief of the PW1, who is the eyewitness, my lord. My lord, more or less, my lord, it is, my lord,
Any motive?
my lord, motive is not there, my lord.
Sudden,
No, my lord.
sudden provocation?
No, my lord, nothing at that such. That has not come out during the, my lord, evidence. Now, my lord, on the last occasion, my lord, by reading this 161, 164, and the examination chief of PW1, that is the eyewitness, I beg to point, my lord, on the last occasion, my lord, the senior, my lord, had pointed out to the fact that in this case, my lord, TIP was not conducted.
Yeah, which one?
TIP was not conducted. That was the point raised by the appellant hearing. I am coming to that, my lord. Now, this is the case, my lord, where the eyewitness knew the accused from before the occurrence, my lord. That is in his statement in 161, 164, and in chief, my lord. So, in a case, my lord, where the accused is known to the witness, my lord, prior to the incident,
161 you cannot rely upon.
My lord,
161 you can take it only for the purpose of contradictions.
my lord, for the, my lord, convenience of the court, my lord, I am reading out all, my lord. Now, in this case, my lord, that the contention raised by the appellant, my lord, saying that TIP was not conducted in this case, my lord. My reply would be, my lord, in a case, my lord, where the accused was known to the, my lord, witnesses, my lord, prior to the occurrence, my lord. In that case, my lord, TIP is not required to be held. And in this case, my lord, I am relying on judgment, my lord, Supreme Court judgment. Thank you. My lord, this is reported in, my lord, in the case of Ramesh Kumar versus State of Punjab. Reported in, my lord, 1994, SSC criminal 67, page 67, my lord.
Page 67.
Page 67. My lord, I'll be providing, my lord. I have made my bullet points as well as all the judgments are here, my lord. And, my lord, here, my lord, at relevant paragraph is 6, my lord, where it is observed, my lord, by the Honorable Supreme Court, my lord. It was held that there is no need for identification.
Page number, relevant page.
Page number, my lord.
You said 67, it starts at 67.
Page is page 67, my lord.
And the relevant portion?
Relevant portion is at page 68, paragraph 6, my lord.
You must give us
I have, my lord. One more. There are three, no? Three. Yeah. These are my bullet points and the authorities relied on, my lord. My lord will produce the last paragraph, my lord. That is on not holding place identification parade, my lord. Page 1, my lord. The last paragraph. Page 1, first front page, my lord. That is my point, my lord.
Ramesh Kumar, yes.
Yes. Well, it was held that there is no need for identification parade where the witnesses already knew who the assailants were. TIP is not a sine qua non in every case. That is, if the facts and circumstances of a case conclusively establish the guilt of the accused, then there is no need to hold TIP. So my case is, my lord, here the eyewitness knew, as per his statement on 161, 164, and examination chief, he has categorically stated that he knew the, my lord, the appellant, that is
So
the
according to identification parade is not required.
Not
The
required.
accused is known to the witnesses.
my lord. The copy of the judgment is at page, my lord. My lord. I'm sorry, my lord, the pagination is not done, but the second judgment is there, my lord. Second judgment. I'm sorry, my apology, my lord. Yes. So next, my lord, I have clarified as to the, my lord, the contention of TIP, my lord. Now, I beg to take your lordships to the statement of PW2, my lord, who is also an eyewitness, my lord.
PW2,
Lordship will kindly come to page 32.
32.
32. This is 161, my lord, at page 32, if I may read, my lord. On examination, he stated that on 29/12/2011, at about 9, he was present at the marketplace as brewer along with victim Sri Subhas Pingrap, where he was assaulted and killed. After talking with him, he went to his own way. After some time, he heard people saying that someone was being beaten up by some man. He rushed to the spot and saw the victim lying unconscious on the ground. He was bleeding from his face at that time. He saw Sri Thom of Saipung village, that is the appellant, who was still hitting the half-dead man. The marketed brewer belongs to Sri Thom. On seeing what had happened to him, he left the spot and went straight to the village. That's all his statement, my lord. Now, Lordship, I will take your lordship to 164 or PW2, my lord. That is at page 62, my lord. Kindly note, my lord, here the magistrate recording 164 is, my lord, recorded that same statement was given as that of Sri Rilang Suklen, that is PW1, my lord. Now, Lordship will kindly come to page 41, that is the chief of the PW2, my lord. Page 41. If I may read, my lord. I have received someone to depose in court today. I could not recollect the date as it happened. My lord will note that the occurrence took place in the year 2011. Chief was recorded in the year 2021 after a decade, my lord. So what I am trying to point out is, my lord, there is bound to crop up some, my lord, minor contradictions, my lord, which is only logical, my lord. If I may read, I could not recollect the date as it happened long time back, but I remember that the incident at the night time of the incident, I was present at Brework marketplace and I saw people gathering there. I heard them talking that the victim, deceased person, was beaten up. On reaching the PO, I saw Sri Thom was still hitting the deceased person, and I ran away and I was scared to see the incident happen. On the same night, I went straight to the village of the deceased person at Songring to inform his relatives that the deceased person was beaten up by Sri Thom, that is the appellant, but I do not know his surname and the resident. On the next morning, I went to Brewer, the PO, and reaching there, I did not see the deceased person, on which later I came to know from the people that the victim was dead and his body was found somewhere near the Brewer market area. My statement was recorded by the magistrate. Exhibit P2 is the statement and P2 by 1 is my signature. I can identify the accused person and is present in the dock today. Now, Lordship, these have, why I read, my Lord, P1, PW1 and PW2, my Lord, that will have a bearing on the statement of PW3 and 4, my Lord. PW3 is the mother of the deceased, my Lord. Lordship will come to page 30. 161 is statement of the mother, my Lord, who was not an eyewitness, my Lord. But here, my Lord, the statement of PW1 and PW is that, my Lord, they had gone straight to the relatives of the deceased and informed the matter. So I'm coming to that, my Lord. Page 30. Page 30.
Any weapon used or stick
My
or
Lord,
hand?
weapons used, that is proved by the, my Lord, post-mortem report, my Lord. Yeah, but weapon was not recovered, my Lord, because dead body was recovered after 2 or 3 days, my Lord, or 1 or 2 days, my Lord. I'll come to that, my Lord. My Lord will see, I'll come to that later on, my Lord. The nature of injuries, my Lord, that is sufficient to prove the guilt of this accused, my Lord. The nature of injuries, my Lord.
See, nature of injuries that resulted in the death may be correct. Whether this convict has done it or not is a point.
The 2 eyewitnesses are there, my
And
Lord.
there are 2 eyewitnesses. They see, by seeing this, he said he was not there. The people were gathering. He went inside and saw, and he was beating with what?
Yes, that is not there.
Ah.
I'll constitute that, my Lord. But when the ocular evidence are, my Lord, present in the case, my Lord, there is no need to look elsewhere, my Lord. I'll come to that.
You can say that he was hitting with a rod or with a hand, all those things. See, probably you may not identify, you may not know the weapon, the night time, all those things. Some instrument was used.
My Lord.
Nothing has been stated.
My Lord. And the recovery of same, non-recovery of same won't be fatal to my case, my Lord. I'll satisfy your lordship, my Lord.
See, when a person goes into the box after a period of 10 years, can he not say that I saw that some weapon was used? I am not able to state what weapon was used. You could have stated
Unfortunately,
that. And when there is a huge crowd, will they be keeping quiet or that person will be hitting him? How many cut injury or injury was there?
My Lord, there are more than 30, my Lord.
13.
And each and every of the injury is fatal, my Lord, enough to cause the death, my Lord. In vital areas, my Lord.
Correct. We take it. But whether this person has done or not is we want the proof. That's
My
all.
Lord, here there are 2 eyewitnesses, my Lord. Named him, my Lord. Named him by name. Also stated we knew him right from before, my Lord, prior to the incident, my Lord.
Yes. I think statement have been recorded after 65 days.
65
It's
days.
not.
My Lord. I'm coming to that, my Lord.
If you have silent for
Yes,
65
yes. My Lord is absolutely correct, my Lord. My Lord, as pointed out, there was a delay of 65 days, my Lord. My Lord, on delay, my Lord, recording of statement number 161 and 164, kindly come to page 5 of my bullet points.
Of your bullet point.
This is reported in the case of my Lord Gautam Jordar versus State of West Bengal, 2021, SSC online, SC, page 9110. Three judges, my Lord. And next page, my Lord. Relevant para is 10, 11, 12, 13, and 14. It is true that there was some delay in recording the statement of the concerned eyewitness, but mere phantom of delay by itself cannot result in rejection of the testimonies. The matter on record definitely established the fear created by the accused. If the witnesses felt terrorized and frightened and did not come forward for some time, the delay in recording their statement stood adequately explained. Nothing has been brought on record to suggest that during the interrogation.
Where have you explained?
My lord, in my case, my lord, initially, my lord, investigation was carried out by a police station without jurisdiction, my lord.
Without?
Jurisdiction, having no territorial jurisdiction, my lord. FIR was lodged at a police station which was more convenient to the, my lord, brief family, my lord. Thereafter, my lord, subsequently it was, my lord, forwarded to the, after some gap, my lord. So, my lord, these are the circumstances. There are lots of, my lord, circumstances.
So that may not be fatal.
My lord.
You are going and giving an FIR to a different police station, not jurisdictional police station, that has been transferred. That may not be fatal.
My lord.
But examining and taking these things after a period of 65 days
My lord.
is a thing.
Absolutely, my lord. But this is a peculiar case where, my lord, IO has changed.
You will not be searching for the police station which has got jurisdiction by using a diary and then go and complain. Somebody is hit. We may not know whether it belongs to this person or that person, this area, that area. That sometimes there may be overlapping.
My lord, is absolutely correct. My lord, this is a peculiar case as it is.
Suppose when we come to
It happens randomly in the.
from Shillong to Meghalaya,
No.
I mean sorry, Shillong to Guwahati to Shillong,
My lord.
incident will have taken place. This side is Shillong, this side is Guwahati.
My lord, this is a
You
case
may
of.
not know.
My lord, this is a case of same district.
This can be, this case of
Same district. My lord, just, and that has been explained. Because the police outpost that had the territorial jurisdiction, my lord, was not motorable at that point of time. That has been stated here, my lord. And my lord, this is a case where 4 IOs has changed hands, my lord, due to transfer and all. So this explains, my lord, why there was a delay in recording the statement.
yes.
Principal, I beg to take your lordships to the statement of PW3, that is the mother of the victim, my lord. At page 30, my lord. That is 161.
Page
30.
13.
30, my lord.
30.
She is not an eyewitness, but, my lord.
Oh, that's what you said.
Yes. Drusilla Pangrup, my lord. If I may read, she is 55 years of age. On examination,
PW3.
my lord. On examination, her, there is a grammatical mistake, my lord. On examination, her, she stated that she is the mother of Sri Savas Pingap. She stated that on 29/12/2011, night time, she received information from Srimati Renika Paslan, wife of Sri Savas Pangrup. Her son, Sri Savas Pangrup, has been beaten by some unknown person at Brewer. My lord, I would like to take a pause here, my lord. Here the PW3, the mother of the victim, is stating that she was informed by her daughter-in-law, that is the wife of the victim, that her son was being beaten up by some people. Accordingly, on receiving this information, she informed the elder at the village at Sunangrim to helping her for searching her son from Brewer. At the same time, all elders of the Sunangrim goes to Brewer and searching him, but on searching they found the body of the Shivas lying dead on the roadside on the way from Brewer to, is not legible, my lord, and the villager carried the dead body to the village for performing the last rituals, rites as per custom. Later they informed the police. That's her statement. Now, my lord, statement during the trial, my lord, that is at page 43. If I may read, my lord, 4343. I have received someone to depose in the court today. I know about this case as I am the mother of the deceased victim and also the complainant in this case. On 29/12/2011, as usual, my son came out from home for a walk in Brewer, but at around 9 p.m., I received a call from my son's wife, Srimati Rimika Personal. Rimika Personal is the PW4 minor. Asking about the whereabouts of my deceased son, I told the wife that maybe my deceased son was still at work. After talking to my deceased son's wife, two men came to my house, namely Sri Rilan Suklen and Compass with. My lord, I'll take a pause here, my lord. In the statement of PW1 and PW2, my lord, they are the eyewitnesses. In their statement, they had categorically informed. After seeing the occurrence, they rushed to inform about the incident, my lord. So this is corroborated by the statement of the my lord PW3, that is the mother of the victim. She has corroborated saying that she was informed by these two persons. On inquiry, whether they know the people behind the murder, and they told me that it was Tom, the assailant, my lord. So PW3 inquired from PW1 and 2, who are the eyewitnesses, whether they knew the assailant, and they categorically stated that it was Tom, the appellant herein, my lord, who murdered him, my lord. But I do not know about the details of Tom's identity. After I heard about this news, I went to the neighbor's place, calling them to accompany me to Brewer, but we could not go as it was late at night. However, my husband let Srolis Pajus went to Brewer, the PO. When my husband reached the PO, he could not find his deceased son, and he returned back home on the same night. Here again, I'll take a pause, my lord. PW1 also stated, PW1 and 2 stated that on the night of the, my lord, occurrence, my lord, the body could not be found. And this is repeated by, my lord, corroborated by PW3. On the next day, my family, along with the villagers of Sonangram village, went to search for the deceased body and found his dead body. And I do not know the place where they found his dead.
See, pay 2 capital A, pay 2 capital A for contradiction.
My lord, my lord.
Pay 2 capital A. The back with the papers.
My lord. Yes. Which is why, my lord, I pointed out to the fact that the chief was recorded, my lord. Chief was recorded after a decade, my lord. There is bound to be some, it is only, my lord, of common sense, my lord, that there will be some contradictions, minor contradictions. If it is not fatal to my case, my lord, they should be overlooked, my lord.
Chief was recorded after a year.
After a decade, my lord, 10 years, my lord.
Chief is going to be tutored.
My lord?
Chief is going to be... That has not come.
In the cross, that has not come, my lord.
The cross-examination.
In the cross, that did not put. So, on 31/12/2011, police came to my house and took the body of the deceased victim for postmortem at Sutunga CHC. And on the same day, after the postmortem, we took the dead body back home and conducted the last rites. Again on 31/12/2000.
Sir, we have read this. Please, what is your argument to page number 2A on these paragraph 5 to 7 or 6 to 7, 6 and 7?
Sorry, my lord.
Page 2A you have. 2A. Page number 2
Of the
body
paper
of
book,
the
my lord.
typeset of papers.
Paper book, my lord.
Paper book.
Two A of the paper book, my lord.
You have this paper book.
My lord.
Page number 2.
My lord.
FIR.
My lord, yes.
Oh.
Translated copy.
For the statement of wife and mother.
Yes.
Sorry, ma'am.
You can take this. Yes.
Hey,
No, whisper with regard to informations received from the eyewitnesses. Even 161 also says so. No, whisper that they have received from
I
eyewitnesses.
think my friend can continue, my lord.
No.
Otherwise,
We are asking
I'm
questions.
praying for uninterrupted, my lord. I want to go with the flow, my lord.
Yes, you argue.
Yes, my lord was pointing to something.
No, page 2A.
My lord.
Read.
We come to inform you that Sri Savas Pangab, aged about 29 years, resident of Sonang Grim went missing on 29/12/2011, and when he was searched by the village people, it was found that he was beaten to death at a place called Briva Ilaka, Nanglia. The incident took place around 9 p.m. You are hereby requested to find the killers and arrest them as per law. I don't see any, my lord, defect in this. If lordship.
On the next day, my family, along with the villagers of so-and-so, went in search of the deceased victim, found the body, and did not know the place where they found his body, as I do not went along with them.
My lord, if I may come to that, my lord, I've got citations to that effect also, my lord, but at this juncture, my lord, I would like to state that, my lord, let's look at the picture here, my lord. A rustic village woman, my lord, who has lost her son, must be stunned psychologically, my lord. So she cannot be, my lord, writing like an author, my lord. There is bound to be some mistake, and FIR is not a, my lord, it need not, my lord, contain all the details, my lord, that comes during the investigation, my lord. That is the Supreme Court's observation, my lord. FIR need not be elaborate, my lord.
That is right.
My lord.
That is it. It's only an information.
And here, my lord,
It's a first information report. That is all.
yes, the mother and the wife, my
Thereafter,
lord,
investigation takes place. All those things are there. 173 is there.
Absolutely.
Any problem? 178 is there. Everything is there.
absolutely,
Yes.
my lord, here, my lord, PW 3 and 4, mother and the wife, my lord, have lost a son and a husband, my lord, and they are rustic village people, my lord, illiterate people.
We take everything.
My lord.
We take that the incident has taken place, the death has caused by using a weapon, so many cuts, the report,
My lord,
medical report,
My lord.
everything tallies, everything weapon is not able to. Our only question is,
My lord.
how are you going to relate the incident
my lord,
to that accused? These are only thing, nothing else.
nothing else.
If you are able to show that, we will decide whether there is any provocation, whether punishment should be reduced or all those things.
My lord,
If you are not able to relate it, how can we convict them?
my lord, yes, absolutely.
This is the only point. That is nothing else.
Absolutely. Then in that case, my lord, I will limit my lord submission to that query. My lord.
That's what. We were starting from the beginning, we are asking the question only.
Okay. My lord, in that case, my lord, the examination chief and cross of my lord, the star witnesses, that are 1 and 2, my lord, the eyewitness, they have categorically stated that they knew the my lord assailant.
They knew
The person who assaulted the my lord, the victim,
who has stated.
PW 1 and 2, my lord.
So ultimately, go back to PW 1 and 2 where
Eyewitness.
Yes.
Because they knew the accused by name and my lord prior to the incident, my lord. What more is required, my lord? And nothing has come to demolish that during the cross, my lord.
Yes. That's all.
My lord, as to the query of the honor, my lords, my lord, that is my submission, my lord. Now, in order to, my lord, fortify my case, my lord, kindly look at the cruel manner in which, my lord, the injuries have been inflicted, my lord. All are fatals, my lord. More than, my lord, 3 dozens of, my lord, and in vital places, my lord. Thereby, my lord, pointing to the very intention and the intensity with which, my lord, with premeditated intention to kill, my lord, that is established. In the nature of injuries also, my lord.
Premeditation is there.
Yes, my lord. I have citation is there, my lord.
So when we asked the question,
My lord.
whether there was any rivalry, you said no. Now you say that there is premeditation is there.
Premeditation, meditation, my lord.
Ah.
My lord, here is a case, my lord, in the statement of PW1 and PW, my lord, there is a brief statement saying that subsequently, my lord, there was some Yeah, my lord. He
He asked you a question whether there was any motive. Now there is no motive initially. Now you say that the motive is there. Page number 34
My lord.
is one.
I'm grateful, my lord.
Is it not? Was it put to cross-examination? Or put it to witness?
Yes, my lord. It's clear. This is 161 statement, my lord. And my lord, in 313 also, my lord, this will be reflected, my lord.
Where is it?
Page 79.
Yes.
Page 34, my lord, statement of accused.
Page?
34, my lord, has referred to his statement of accused during custody.
Statement of the accused.
Yes.
Correct.
Yes.
Whether you have stated that.
No,
have you done anything?
nothing is
That was the thing
Yes,
you're
yes.
asking him.
Yes.
It's not admissible in evidence.
Yes.
Whether it was subject to cross-examination.
My lord, my lord is absolutely correct.
Any question on this line, whether you need not show it to the witness, because 161 need not be there at all.
My lord is.
Any suggestion that both of you went and committed this offence, murder? Any question? Suggestion was there.
My lord, I'll take just 2 minutes, my lord.
There's a meeting at 12:30. At 12:30.
My lord will come to my lord. Page 83, question number 15, my lord.
83.
Initially, my lord, here 2 accused persons were arrested, my lord. So based on the statement of the co-accused, my lord, who was later on, my lord, dropped from the case, my lord, at question number 15, my lord, he was confronted with this, if I may read, my lord.
Question number
15, my lord.
15.
Question. PW10 also stated that accused Nidaman Chulet stated that Nidaman Chulet is one of the co-accused, my lord, at that point of time. That on 29/12/2011, he was present at Brewer and was running the illegal market, ration store, video hall and gambling. And in this connection with the incident that Sri Swab Pingap has been murdered at Brewer, but he denied his involvement, but that on the same night that he, the victim, and you, Thambar Sadab, was taking liquor together, and that the deceased with you, Thambar Sadab, started the war of words between them, but that what happened outside he does not know, but only on the next day that he came to know that the Swas Pangrab has been murdered, and that he stated that he, the Nidaman Chulet, along with you, Thambar Sadab, were running the market at Brewer. What do you have to say? I do not know what Nidaman Chulet has said. In fact, I do not know him, and he is not my friend. I never run any illegal market with him. I did not drink any liquor with the victim, as I do not know him. I do not
We'll
know.
continue either tomorrow or Monday?
My lord, after a week in that case, my lord, I have got plenty of matters, my lord.
What is that? We already, we have got a meeting, that is why we are raising.
My lord.
Otherwise, otherwise we are ready to hear you in the afternoon.
Thursday, my lord. Thursday, my lord.
16, we have got about.
Convenience of my friend.
Thursday, sir.
16, we have got number of cases, no? 20 cases. 16, we have got about 20 cases.
My lord, any convenient date, my lord.
Monday.
Subject to convenience of my lord.
20th. How is it? On 20th? 21st? How many?
28th, my lord. 20.
20th. 20th.
My lord.
20th.
Third and part. Continuation.
My lord, I further beg to mention, my lord, item 10 and 11, my lord. I am not prepared today. I will need some time, my lord. 10 and 11, my lord.
We'll give a date.
Deeply obliged.
For 10 and 11.
My lord.
POCSO.
No, my lord. 302.
My lord, item 11, I'm appearing for the appellant, my lord.
Item 10 and 11.
My lord, I'm not in 10.
Madam?
I am appearing only in item 11, my lord, not in item 10.
Yes, yes. Your friend is on the other side. He wants time.
Yes.
No,
What is this?
My lord,
Both are
I don't have.
302.
Yes, lordship. Item number 1030.
302. Yes. We'll give a date. Yes, thereafter.
Lord, for item 11, if it could be fixed on 6th of June, my lord, subject to your lordship's convenience.
Yes, we'll see. Yes.
Then
10 and 11.
we'll keep it together.
What is the next matter? Is item 9.
Deeply obliged.
Item 9.
Lordship is POCSO matter, lordship. POCSO.
Yes.
This lordship, the conviction is under section 3A and 4. Here, lordship.
Other side.
I'm appearing for the statement.